Looks like we're just getting some people starting to flood in now. We might just give it a moment or two just to make sure everyone's in and settled. Here we go, they're streaming in now. Hello everyone and welcome. Let's just wait a little bit longer until everyone's in. Got a very exciting event for you all. Can see a few more names popping in now, but I think we're at a good level here, so we might get underway. Thank you for your patience, everyone. Apologies for the tech gremlins there. Hello and welcome to the Dear Judge, Please Help part of the County Court's virtual VCE Legal Studies Week. My name is Ryan and I'll be your moderator for this event. I would like to begin by acknowledging the traditional owners of the land from which I am speaking, the peoples of the Kulin Nation. I pay my respects to their elders past, present, and emerging. All the attendees of this event have their cameras and mics turned off, but if you have any questions or comments, you can type them into the Q&A box at any time during the session. Joining us today from the Criminal Division is Judge Murphy, and from the Commercial Division, we have Judge Marks. And joining us from the Common Law Division is Judge Pillay. I now invite the judges to tell you a little bit about themselves before we begin the general discussion. Judge Murphy, could I please ask that you kick things off for us?
Yes, thanks very much, Ryan, and welcome to members, to students for their VCE. This is, for you, no doubt, a very strange year, and it's fair to say that for the courts it's been a very strange year, certainly from about February onwards. Look, I've been on this court for 14 years, which makes me relatively senior. I started off my life about your age. I was going to do agricultural science. Then in about October of my, what was then matric year, I changed it to economics and I did a degree at Monash and then took a couple of years off and then did law at Melbourne. And then after that, I worked as a solicitor, as a judge's associate, and then including at one stage with Justice Kirby, and then worked for the Attorney General here in Victoria, Jim Kennan, who's now passed away, and then joined the bar. And it was at the bar for some years, worked as a sort of quasi-judicial officer in the Industrial Relations Court, then went back to the bar, and then in 2006 was invited to join this court. I mainly practiced in industrial law and administrative law, rather than criminal law, although I did do a couple of criminal trials and some pleas. And so since I've been on the court, I've been doing both criminal work and also civil work as well, and a bit of commercial as well. So look, there's many other things I could tell you, but I'll let you ask the questions and then hope to assist you.
Fantastic. Judge Marks, could I please get your background, please, for the court?
Yes, indeed. Well, can I echo what Judge Murphy has just said? Welcome to all of you. You have had an extraordinary year. We at the court have also had a very unusual year. For example, I've been working remotely, running trials remotely from home since about March, as have some of the other judges. Everything's happening on Zoom just as, or something like that, as I know it's been happening for you. My background is that I wasn't very much older than most of you when I realised that I wanted to become a barrister. Let me just back up a tiny bit from that and tell you that my dream when I was in about year 11 was that I thought I might become a doctor. Fortunately, I worked out I hated the sight of blood and that it made me feel queasy. So I had to do a quick pivot, as the phrase is now. And I decided that I really did rather like debating things and arguing things, and perhaps the law would be interesting. Very good decision for me as it happened. At 25 years old, I became a barrister after being at a law firm for a little while. So as a barrister, I then spent the next 27 years arguing cases for people, meeting clients who had problems they needed some help with, finding out all about it, and then going and arguing that case where necessary in front of judges like me. I really loved it. And then about 4 years ago, I was asked if I would become a judge. And obviously, you know the answer to that because I'm sitting here, and I joined the county court. I sit in the commercial division, so I deal with cases involving money in the main. But believe it or not, that affects everybody at some stage in their lives. Maybe they've entered into a contract, promised to be paid something, did a deal and haven't been paid it. Maybe they bought a business and the business has gone wrong. Maybe they both were all involved in purchasing a property and now they're arguing over who gets to keep it. So they're the sorts of cases that I do in that division. That's probably enough from me for an introduction.
Fantastic, Judge Marks. Thank you very much. And Judge Pillay, could I please get your background for the court as well?
Welcome to all the students online at the moment. My name is Arushin Pillay. I've been a judge only a short period of time, a year, but prior to that, and going right back to where you are now, I left school. I had come to Australia at a young age, and I grew up in a small town in Tasmania called Launceston. At 18, I left Launceston and went to Hobart, where I went to university there for 5 years. And then I came to Melbourne looking for opportunity. That didn't quite work out, and I spent a bit of time unemployed, but I eventually landed a job at Slater and Gordon, a personal injuries firm, and did a lot of different kinds of personal injuries work. And that's really followed me through my legal career. I did a lot of work for people injured in work cover accidents or transport accidents, who'd had dust diseases or who had been sexually abused. But that took a bit of a toll. And so after about 3 years, I took a year off. But when I returned, I was determined to go to the bar, and I went to the bar in about 2003 and was a barrister until last year. Predominantly, I worked in the same areas, personal injuries, and that's the kind of work that I do at the court now. All different types of common law personal injuries work. I'm very pleased to answer any questions that you've got for me.
Fantastic, Judge Pillay. Thank you very much for that. I now have a few questions to get the conversation started, and I'll also relay any questions that come through. So please feel free to drop some questions there in the Q&A box, and I can fire them off. Judge Pillay, if I may, we might start with you. And the question we've got here is, how does the county court fit into the Victorian courts hierarchy?
Well, the county court is really the mid-tier, if you like. Cases we normally call the magistrates' court, the first port of call. That's where a lot of small civil claims go, but also the majority of criminal work starts there, either as summary pleas or summary matters, or in the committal stream. That's where the serious cases begin. Then it moves up to the county court. The county court is the predominant trial court for serious criminal cases in Victoria. So that's what we do here. As well, we run most of the personal injuries cases in Victoria. We sit as judge-alone trials, or we have juries. And then for more significant and complex matters, there's the Supreme Court and the Court of Appeal. And just a side note, administrative matters, which are in dispute, so sometimes between landlords and tenants or small commercial disputes, can also go to VCAT, the Victorian Civil and Administrative Tribunal.
And can I add to that excellent summary that I remember learning about how all the courts fit together at school and finding it incredibly boring. But once you work out how it happens, it does make a lot more sense of what you're reading in the papers. You might have heard that 2 judges were just appointed yesterday to our highest court that sits right up the top. And now you'll know where that fits in into the jurisdictional areas.
Fantastic, judges. Thank you very much. Judge Marks, just on sort of the hierarchies, and I guess focusing more on us here at the county court, how do all the divisions differ? Do matters ever overlap between civil and criminal?
No, they don't overlap as such, although sometimes you'll find the same people popping up in them. So the criminal sorts of cases will be where someone has assaulted someone or they've hurt someone in some way. Judge Murphy's really better to talk about all of that. That same person, of course, might also get sued civilly for assault and for causing some damage. And so they might end up in a different case in the commercial division. They might get, the person that they've injured might be seriously injured. So they might then end up in front of someone like Judge Pillay. But there's not it's not that you'll have the same judges sitting on the same case.
Could I just add to that in relation to overlap? I'm working on a decision at the moment involving confiscation of the proceeds of crime. The county court does the bulk of cases involving confiscation of assets that might have been as a result of criminal activity, or where the assets, particular assets being houses, cars, etc., are suspected by the authorities of being the proceeds of crime. And the authorities, the AFP, the federal police and the Victorian police have the right to get those assets restrained if they allege a criminal activity. And the people whose names the assets are in have got to then prove that they got them lawfully. And so that's the civil aspect of it, which is dealt in the civil division of the court that Judge Pillay is involved with. And the criminal aspect, the actual crime, might be dealt with in the criminal stream. And so you may have seen on the news about 3 months ago involving a Cessna plane that failed to take off with a load of drugs in Papua New Guinea. Now, that plane had been at Tyab actually at one stage. So that's given rise to a big criminal case against the leaders of the syndicate, but it's also given rise to a big confiscation case involving a number of different companies that's assets that I'm currently dealing with. So that's how parts of the jurisdictions of the civil and the criminal area overlap.
Fantastic, Judge Murphy. Thank you very much. And we've just had a question pop in here, and I might actually go back to you here, Judge Murphy. The question is, how has the court changed in your view over time, over the years?
Well, it's interesting. In the criminal area, the cases have got more complex because the investigative power of the police has got more elaborate. So you've got more telephone intercepts that people might use in proving cases, or Facebook messages or material on devices, CCTV footage, DNA evidence, so that the cases that are put up by the prosecution against an accused individual, they're often stronger cases than what they might have been 20 years ago, which is just someone giving some oral evidence about what happened to them. And so the cases are bigger. There's been changes because it's only relatively recently that records of interview were the subject of a videotape. So we're getting videotaped evidence. There's been changes in the last decade or so where in sex cases, the complainant, the person making the allegation, it's all done by on a remote facility, so you don't see people in the courtroom. So, and even as Judge Marks mentioned, in the last, since March, we're in the criminal system, we've had to, there's no jury trials at the moment, and we're moving to some judge-alone trials, but even in the non-jury matters, we're dealing with people. It's surreal, really, because a court is a room, it's a building. There's the majesty of the architecture, which doesn't exist if the prisoner might be sitting in a prison cell somewhere and the defence counsel's at home and the prosecutor's in some other office, and the judge might be sitting at home or sitting in an empty courtroom. So things have changed, but we're hoping to go back to business sooner rather than later, but who knows?
Can I just add something there? I just want to say it's magnificent architecture behind you, Judge Murphy. And one of the things we've been able to do in having Zoom hearings is often see where people are actually there living now. So I had an application the other day by someone saying, look, I'm not ready to proceed with this trial because I'm in the middle of moving house. Now, you might have once thought, well, is that true or not? Have they sworn an affidavit? But as he videoed, there were all these boxes right behind him, and it looked like very much right. Can I just add that from my point of view, what I've seen in the court change, as well as all the things Judge Murphy's mentioned, it's got bigger. There are more judges. There are a lot more women judges as well. It's now 45% female judges. When I started as a young barrister at 25, there weren't any female judges in Victoria. I had my first case in front of a female judge when I went to Sydney to the federal court there. So there's been that change. It's a more diverse judiciary altogether, and there's a lot more movement to be made there, but it's on the go. And I'd also agree with Judge Murphy, there's so much more that's done in terms of IT now. So in our commercial cases, you will now have reams of cases involving WhatsApp, things that people have exchanged. We're having cases where we have to look at the significance of someone's emoji, what they've sent. Where once upon a time it might have been who said what and what do you remember, now there's so much more that is recollected because of all the computer technology. So there are some of the changes I've seen.
Well, we've got a perfectly timed question here, and it's more to do with the virtual hearings and how hearings are going more online. Judge Marks, if I may, how have you found moving to virtual hearings or more of them?
Well, can I first of all say that, like Judge Murphy, it's lovely to be in a real courtroom, and like everyone in Victoria, it's lovely to be around real people. And there's no doubt that it is fantastic when everyone can come into a real courtroom and realise that this very serious matter is happening. They're in a very serious place where their answers really matter and so on. But I can say from the point of view of running civil cases, at least, it's worked pretty well. I'm very well, I've set myself up at home so that I've got multiple screens. I'll have the Zoom hearing going where I can very clearly see. I can see probably more clearly than I can in court, witnesses' faces and so on. You start to notice when they're looking a little bit worried or a little bit dodgy or something like that. And I've got the documents and I'm able to communicate separately with my associates about different things that need to happen. Some people have found it, I think, very convenient. Instead of having to spend hours driving into the city, finding a park and then maybe waiting for some time before the court case gets started, they can just get in online when they can. So from that point of view, it's been pretty good. I've had to get, as you can see, I'm actually doing this from home as well. So we try to make it as formal as we can. Those who are part of the court hearing, even though it's virtual, are very aware that they are in a court hearing. My associate will be dressed in her associate's robes. You'll see we have the court background. People still have to swear to tell the truth, the whole truth, and so on. I have not noticed people acting more informally or anything as a result. But I did accidentally the other day, after a short break, getting ready just before the camera came back on, I put back on my robes, jumped in front of the camera, was about to click switch when I realised I'd also put my mask on. That's the sort of habit we've got into here in Victoria. So I had to whip the mask off and on we went.
Nothing wrong with those extra safety measures, Judge. We've got actually another good question here. Judge Pillay, I might pivot towards yourself. We've got a question here. When would you have a jury trial for a commercial or a common law matter?
Well, for common law matters, normally it's up to one of the parties to select a jury, and they normally do that at the time when the case first begins. Normally, that is in non-COVID times, we would hold common law juries all the time. Sometimes it's not appropriate for a jury, but that's rare. It's really at the discretion of the parties as to whether they select a jury. Judge Marks would be able to answer more in respect of commercial matters.
Yes, I'm sorry. What was the question again? Once I knew it wasn't directed at me, I started thinking of something else. I'm sorry. Long day.
That's okay, Judge. The question is, when would you have a jury trial for a commercial or a common law matter?
Oh, in commercial, it's extremely rare. I've never had I once as a young barrister had a jury. It was over whether or not someone had been given a bad haircut. Someone had sued for about $50,000 25 years ago. So I heard lots of evidence about that. It was a jury of 6. It's very rare in commercial matters. Mostly they're done in front of a judge like me, and at the end of the case, I need to give a written judgment so that the parties can see I've carefully considered all the evidence that's been given, listened to all the argument, and then explain what the answer is. And if any of you want to look at what those sorts of written judgments look like, our county court website has some examples, or there's a website called AUSTLI, AUSTLII, where you can look at judgments that have been written from the High Court down to all different judgments. You might find that zipping across your social media stream is this case has just happened. You can type in the name of the case and you'll very often find what are the reasons, not just what the media might tell you in the very brief time they have to tell you something, but if you want to know more about it. So that's open to everybody.
Just to add, as a result of the COVID crisis, the government did change the law to allow judge-alone trials. And it's got to be by application of the parties, and a judge has got to agree. And so there's been about a dozen judge-alone trials in criminal matters ordered, and there's been, I think, about 10 decisions given. In each case, the accused person was found not guilty or guilty of a lesser offence. So there's a recent decision of a judge in the Supreme Court, Justice Inseriti, where involved a gentleman out in Box Hill who assaulted his sister and put her in the boot of the car and she was dead. And the judge had to decide whether or not he had murdered her or whether it was a case of manslaughter, unlawful and dangerous act. And so the judge had to sort of go through quite a detailed analysis of the medical evidence and what he'd said at the time in order to decide whether he had the intention to murder her or commit or inflict very serious injury. And the judge held that she wasn't satisfied of that beyond reasonable doubt, but found him guilty of manslaughter or death by an unlawful and dangerous act. So you're likely to see a few more of those cases in the next, from now on probably. But it's very important from the point of view, your point of view as moving into adulthood, is that you will in your life be called up for jury service. And that's a very important civic obligation, because the law has said that the decision as to whether or not a person is guilty or not guilty of a serious offence is not to be dealt with by judges, but by a jury of 12. And so it's a very important civic responsibility, which is sort of suspended at the moment due to COVID, but it will revive. And so when you do get a jury summons, as you will in some time of your life, I'd ask you to really take it very seriously. It's in the Constitution, Section 80, that says you're entitled to a trial by jury for a Commonwealth matter. And so you will get it. It is a sort of a vestige of ancient times, but it's a very important one that I always emphasise when I'm speaking to students in normal times.
Thank you very much, Judge Murphy. In non-COVID times, the courtrooms can sometimes be quite packed, but also there are times where a court might be closed. Judge Pillay, if you could you please explain, A, who is allowed in a court normally in non-COVID times when people are allowed in, and B, when would a judge maybe look to close a court hearing?
The start to that question is a basic principle, which is that we have a system which is open. It's open and transparent. And that is so that members of the community can have faith in what's being done in court. So the notion is that everything that happens in the court is open for the public, the citizens, to observe, to make sure, firstly, that people are getting a fair trial. Secondly, to make sure that judges aren't abusing their power. And that's why we always say justice must be seen as well as done. That's why our courts are open. And that's the starting fundamental principle of courthouses. They are open places. However, at times we do have responsibilities to close the courts where something particular might be happening, which might not be proper for the public to see. So, for example, at times there might be extensive amounts of, for example, child pornographic material which is being shown. And at times that will mean that certain victims are being shown. Now, we would often close the court in that circumstance so that members of the public don't come in and see the child victims, for example, who are displayed in photographs. But I would just go back to that point that I'm making, which is that that is an exception. And we take it very seriously when we have to close a court and when application is made to close the court for those reasons.
And could I add to that even in these COVID times, the same principle applies. And if people can ask to be joined in to watch a hearing that's going on electronically. So, you know, if you want to observe a case, you can find out from the court how you do that. I've had requests sent through to my associates, and I always say yes. Unless there's some reason, such as Judge Pillay has indicated, I would have to be satisfied of one of the legal bases for closing the courtroom. I've never closed one of mine yet. I haven't had a case that's required it. So if someone wants to watch a Zoom case, they can do that as well. And at the moment, while you can't walk into physical court cases, bear that in mind. There may be something you could watch in a different way. Some cases are streamed too. The Supreme Court in particular has done that with some major cases that affect thousands of people, some of those class actions.
Fantastic, Judge Marks. Thank you. One thing that we've got through here, good question, is the court seeing more self-represented litigants? Are people looking to try and represent themselves more in court? Judge Murphy, I might ask you to answer this one, if I may.
In the criminal division, we don't see very many self-represented litigants in the more serious matters with a jury trial, because it's very hard to run your own case if in front of a jury. And in fact, there's a provision in the law that allows the court to direct that the Legal Aid Commission provide aid to lawyers, aid to an unrepresented litigant. So generally you won't, and then there's plenty of people who will appear for people pro bono for free. At the same time, there is a group of people who want to fight their cases on their own, often in the magistrates, they appeal against a magistrate's decision, a minor criminal matter, and they come to our court, so they've got to be dealt with. And in intervention orders, often it's hard to get legal aid. Disputes between neighbours or disputes within broken down relationships, even within families, one will be represented, the other won't be, and so that imposes a very high obligation on a judge or judicial officer hearing the matter to ensure that they get a fair hearing of the matter. But that's why, in a sense, the VCAT takes a lot of the commercial and minor building disputes and that sort of thing. Is they're used to civil disputes. They deal with a lot of unrepresented litigants. In our courts, we do get a trickle of them. I'm not saying they don't, and they do present challenges, but not that many that I've come across.
We get them more in civil, but again, I would say, to be honest, 90% or something of the cases that are instigated in civil, so someone sues, get settled before they actually get to a full hearing. We have a very good system where there's an opportunity. People will go and have a mediation if necessary. We'll have early interlocutory applications along the way, and there's an opportunity for people to resolve them. That can save them a lot of money and a huge amount of stress. If they don't settle, then they have the opportunity to be in front of a judge. I would think that, I don't have the statistic to hand, I've only had a few cases run with a self-represented litigant actually running the whole trial. But I've often heard from them at the stage before that. So I think a lot of those cases do resolve. But sometimes they can't afford to have a lawyer, or they think they're better able to argue the case themselves. And as Judge Murphy says, our job is to make sure that we understand what they're saying as much as we can and that they're given justice. So that means sometimes us having to work a bit harder to understand what their argument might be, because they haven't had the legal training. I know how lost I get when I go into a hospital or something and there's all the different jargon there. Well, there's legal jargon too, and we try to make it as simple as possible. But that's one of the difficulties that can arise.
Judge Pillay, if I may, in your opinion, is there some correlation between having a quote unquote superstar legal team and possibly having a higher chance of winning a case?
Yes, I think there's no doubt about that. It helps enormously. And you'll see in the high profile criminal cases, for example, no expense is spared in getting very senior experienced counsel who have very strong representations, very strong reputations. It is in some ways, litigation, a process of intimidation of the other side in order to advance your case. And that can happen in any number of ways. And I always say it's as much about doing the hard work as presenting your work well. So when you can combine that in a superstar legal team, as the question suggests, it's a pretty telling combination. It doesn't always win out, that's true, but it certainly does help.
Fantastic. Thank you, Judge. We've got another question popping in here. How important is precedent when making your decisions? Judge Murphy, I might just pivot to you for this one.
Well, it depends on the type of decision, but in a civil case, say, for example, you're interpreting a provision of a contract, then if it's been dealt with by a previous court, then you should generally follow it. In the criminal law, precedent is very important in the sense that if a particular section of an act creating an offence has been determined by a higher court, then you should follow that when you're interpreting the law. In sentencing, precedent is sort of got a different term in the sense that when you're sentencing someone, equal justice, in a sense, requires that you should, if two people commit the same crime, then all things being equal, they ought to get about the same sentence. But of course, often all things are not equal. But the way the system operates, the Court of Appeal, when they hear appeals against sentencing decisions by judges, they might lay down some comments about the appropriate sentence for particular types of offence, or whether particular features should give rise to higher sentences. And then it's a judge is duty bound to try and give effect to those if they get a similar matter. So precedent is important, and a judge like the three of us is not entitled to go off on a frolic of their own, and they're required to follow other judges who've made the same decision on the same piece of legislation or in interstate. And sometimes, and that's the point about the High Court, you might get conflict between two states on a particular interpretation of common legislation, and that takes the High Court to determine that, being at the apex of our judicial system. But at the level that we're at, appeals against our decisions go to the Court of Appeal, and then it tries to follow cases from other states if they're comparable, and then if there's conflict, then it can go to the High Court. But generally, judges have got to follow precedent. And if any of the students have been watching the situation in America with the confirmation of Judge Barrett, and she was asked a number of times about whether she'd follow particular precedents, and she sort of had a boilerplate response saying, I'll consider the law and consider each case on its merit. And she even on the US Supreme Court, they've effectively got to try and follow precedent, but there are certain doctrines that they've developed where they'll decide to stray or move from a precedent if they think it's wrong or it needs to be changed or updated. So it's a moving feast in a sense.
Fantastic. Thank you very much, Judge
I'd just
Murphy.
like to add to that the idea, of course, behind precedent is it gives people some certainty. You've only got to see two children fighting over a dropped ice cream to know how important notions of fairness are as to, you know, who dropped it and who's entitled to it. And I still remember my 3-year-old dropping an ice cream as she was walking towards me holding two, and she dropped one in the sand and said, "Mum, I dropped your ice cream." But the arguments that would happen would always be between the children, whose bit of cake was bigger. So what we get with precedent is some certainty. This is what happened last time, and this is why we should apply it this time. And then another barrister will say, but it's a bit different. The facts are a bit different here, so you should change things. So you're always looking at what's the closest analogy we've got. But the idea is to give people a sense that it's not the Wild West. There's some rules and they'll be applied fairly similarly across. And I think in Australia, we get that pretty right.
Thank you, Judge Marks. We've had a follow-up question to that, though. Are there any features or are there any particulars that could lead a judge to potentially stray away from a precedent?
Perhaps Judge Pillow, do you want to?
Yes, there are. While there might be, and as this is really picking up what Judge Marks said, while you might have precedent and it's useful, it is amazing that we continue to get factual circumstances which have never occurred before or have never been the subject of a judicial ruling, which we can look at and say, well, this is exactly the same, we'll just follow the same rules here. Normally there is some fact which takes it outside of previously decided cases, and that means the principle is modified, or we might have to bring in another principle, and then we've got the interplay of two principles to help us decide a case. But really, the level of decision-making that we're at in the county court means that we are bound to apply those principles which are handed down from the High Court, or I should say the superior courts to us, the Court of Appeal primarily. And it is not the position that we can stray from that without very, very good reason. For example, where you have exactly the same cases in the Court of Appeal and the one before us, we would not be allowed to make a different decision.
That's right.
Without being able to find some way to distinguish our case from that case in the Superior Court.
Yes, and I was just going to add to that, that sometimes someone will quote me a decision from a judge who's at either the same level of the hierarchy or below, or from perhaps an interstate court where I'm not directly bound to follow, and I might not agree with that decision. In those circumstances, it's not in fact precedent for me, but it will be somewhere I'll go, well, look, I see that in New South Wales they've said this, but I think the situation's X. And that might be when you end up with a decision being made in the High Court. Sometimes it's been suggested before to go, who's right in that situation?
Well, that happened a couple of years ago when in sentencing, the judge is required to take into account current sentencing practices for particular offences and as one of a number of factors. And the view in Victoria was that the current sentencing practices had to be given substantive weight in a sentencing decision. And the Director of Public Prosecutions formed the view that the sentences for particular offence of incest was too low and the judges were not having regard to the maximum penalty. And that had been determined by the Court of Appeal that the judges were doing it right, but it went to the High Court and the High Court said, no, all judges have been getting it wrong. This is the way to do it. And since that time, judges have had to deal with those particular provisions of the Sentencing Act differently in accordance with the High Court decision. So current sentencing practices is only one particular factor to take into account.
Fantastic. Thank you very much, Judge Murphy. Changing gears slightly, the court sees a range of members of the community come before the court. But in particular with youthful alleged offenders, in addressing them and in their hearings, do you address them differently? Do things run a little bit differently for younger accused? Judge Murphy, I might get your thoughts on this one.
Well, yes, you've got to be very, very careful with young offenders. First of all, the Children's Court deals with most offenders, young offenders who are under 18, but there is some of the more serious matters do become before our court. And you read in the paper today, there's a group of 5 or 6 youths aged between 13 and 15, and they're in the Supreme Court on a charge of murder. So you've got that, and so they're in unfamiliar circumstances. Then you've got the other issue dealing with younger offenders, is that in relation to the Sentencing Act, in sentencing them, and most of them plead guilty, the court has got to take into account their rehabilitation, the need to get them back into society and rehabilitate them so they don't reoffend, as the primary sentencing objective, rather than just punishment. And that applies until they're age 21. So you've got to take that into account in the disposition that you give them, and whether you decide to in fact send them to a youth justice centre confinement or give them some disposition in the community. But then on top of that, you've also got what's well known in, and I say this to students too, most of our offenders are males, and it's well known, the psychological research, that male brains don't fully form until they're about 25, and some of the literature will say till they're about 30, and some will say never. But so that is a very important consideration when you're looking at considering the moral culpability for particular offences, for particular conduct, that really you are dealing with people whose brains are immature, possibly less mature than a female of the same age. And so that makes it very difficult sentencing them. And then, of course, the other issue you get, and I've literally had a couple in the last week or so, of people who are in their 20s, they've had a terrible upbringing, no father, violence when they're young, dropping out of school, use of drugs when they're early. So you're then getting lack of education, lack of any occupational abilities, possibly mental health problems, and then they're just being recycled through the criminal justice system. And that gets how to deal with them is very difficult, particularly in these days when there's so many legal drugs around, whether it be cannabis, which does cause schizophrenia, and then you've got, of course, moving into the heavier drugs like ice. And eventually the community really demands that they be contained by sentences that keep them off the streets to protect the community.
Thank you, Judge Murphy. Judge Marks, in a civil matter, would there be greater, emphasis on mitigation in a civil matter for someone who might be younger entering into negotiations?
It really doesn't arise in the same way in certainly the commercial cases I have. They're about really one side saying to the other, you owe me money. And so I don't particularly get young people in the court. I mean, one can imagine occasionally someone would turn up, someone under 18, to give evidence about, look, this was what the deal was, or I heard this, or I saw this. But in a much lighter vein, I can tell you that my favourite part of being a judge is dealing with the very youngest people who sometimes come before me, and they're coming because we also have an adoption area. So sometimes people are adopting a young baby or a young child, and a judge needs to approve that adoption, and that is always a really delightful thing. And I'll find that the court is full of all the family who are so excited to be adopting this child. The court even gives out a teddy bear, and it's a very nice, happy time, because very often, of course, you'd imagine all the work we do deals with people in stress. If they're not in stress because they've been charged with something or they've been a victim of something, they're in stress because their life is falling apart in some other way. They've sued or been sued. And so to have that area where people come and it's such a happy thing is nice. So they're the youngest people I deal with. those babies.
Just one other point about younger offenders is we are getting a number of driving offences involving young people. And, you know, when you turn 18, you get a car, they're a lethal weapon, particularly if it's mixed with alcohol and drugs, and distracted driving, people on their text on their phone, and suddenly they hit a cyclist and they've either killed them or caused them serious injury, and they come before us. That's a matter that I've got to mention in terms of looking at the changes in the law in the time that I've been a judge, is that there's many more serious traffic offences coming up involving injury, serious injury and death, involving driving, whereas in the past people just put it down to an accident. Now they're being charged with a criminal offence, whether dangerous driving causing death, or negligent driving causing serious injury, or reckless driving, reckless endangerment. So we're getting a number of younger people in that sense, and they're very difficult sentencing exercises because people often don't have prior convictions, but the community is demanding that the judges impose sentences designed to deter people and make people realise that having a driving licence is a great privilege and you can do a lot of damage.
Yeah, and can I add to that? One of the things if I was seeing you all in person, I'd actually say to you, you know, here you all are sitting in court watching this now. Can you think of all the other ways you might come to the court? And the answers will come. They might come as a defendant. They might come as the victim. You might come as the witness. You saw something go on. You might come later as a police officer or as a social worker. What you don't want to do is come because you have been charged because of something absolutely stupid you've done in one silly second. And they are what I hear some of the hardest cases for the criminal judges and lawyers to deal with, is when someone, maybe they're 18, maybe they're 19, maybe they're 20, and they're just on their phone for a split second, quick text, and they have killed someone. And then it's over to Judge Murphy and the other judges because they have just broken the law in the most serious way, caused the most serious damage. And 1 second earlier, they were fine. So can I implore you, put those phones away when you're driving, put them in the boot if you can't, otherwise resist the temptation. And I know what a temptation it is. I've watched The Social Dilemma and I'm a human like the rest of you, but don't come to court because of a problem like that.
Good advice, Judge. Thank you very much for that. Switching gears again, if I may, Judge Pillay, you're one of the court's newest judicial appointments. We've got a question here. What's one of the most interesting things about being a judge at the county court?
I think it's the responsibility, but it's also the loneliness. So the responsibility, for example, as Judge Murphy was talking about, when you're sentencing a young offender and you have before you someone who's 21 and committed an offence, you have the power at that point to crush all hope and to crush all rehabilitative prospects by sending them to jail. And on the other hand, if you go too light, then they don't realise the seriousness of the situation. But that's a large responsibility, I find. I find that difficult to bear. But for a young person at 21, what happens in that courtroom over that half an hour in many ways can set them on two different paths. And that's why I say it's a great responsibility, but it's also exercised in great loneliness because it's a decision that you make. And I think those two things are really what struck me over the last year.
Thank you, Judge Pillay. Judge Marks, in a similar vein, do decisions weigh on you after the fact, after you've made a decision, there's been a result? Do you find yourself thinking back about matters?
Certainly I do, and I'd agree with Judge Pillay that there's a loneliness in having to make that decision. You can't be chatting away with your friends about it. You can't be talking to your old colleagues. It's a decision for you. You're the only one hearing all the evidence. And you're the one you're looking at the people it concerns. This might mean everything to them, even in a civil. It might be the difference between whether they get to retire or work for the rest of their lives. It might be whether they have a house or not. It might be whether or not they go bankrupt. It might be whether their family then demolishes because they're under so much pressure. So you're very aware of that. What has been found again and again, though, is that if people feel they've really been listened to, they're far more willing to accept the decision that is made. Not saying everybody will always, but I think the most important thing we can do as judges, apart from bringing all of our energy to making sure we understand what's being argued and trying to get to the right decision, is to really respect that the people there are doing their best to explain what happened. You're going to believe some, you're not going to believe others, but a lot of people may just be confused, and you've got to decide in the end what is right. That is the job. Nobody wants me to get on the bench and say, well, look, that was all a very interesting case, but you know what? Don't know the answer. That's not something we're able to do.
I think the other point that relates to both what both Judge Pillay and Judge Marks have said is that in a lot of cases, there's no right answer. So to give, Judge Pillay mentioned a 21-year-old, two judges looking at the facts about a particular event. One judge might say, well, he's got to go to jail. Another judge might say he's worth one more trial, or she's worth one more go.
Could I just add to that? Of course, you will also have learnt about the appeal process. So at the end of the day, if I make the wrong decision in someone's view, they can appeal that. And then 3 other judges will decide what's happened. That's one of the benefits of the way we have our system. So sometimes you'll see that the decision changes at the next level. Very occasionally, it even changes again after that. But that's the way it works.
Thank you very much, Judge Marks. In civil cases, is that the same? Are they able to be, are amounts able to be changed and varied in higher jurisdictions?
Somebody might sue, so for example, someone might sue for $550,000 in a case in front of me. And I might decide, having heard all of the different arguments, that they're going to get up on $432,000. That's because I liked arguments A, B, and C, and I didn't like arguments D, E, and F. I suppose it could go up a level, and the Court of Appeal might decide, oh, actually, they're worth $320,000 or something. They might find for different factors, but that will be because they've decided specific issues differently to me. It's so done in that way. And there's discretion, of course. Sometimes people sue for damages, and there's a discretionary element about what it might be. So again, you might have different judges decide something different there, but would operate in that way.
Fantastic, thank you. Judge Pillay, with that level of discretion, and I guess, to put it another way, flexibility, in your opinion, Judge, is there enough flexibility for judges to be able to make their decisions with a level of variance depending on severity of and what's been put forward to yourself in court?
Certainly in the civil common law jurisdiction where we deal with personal injuries matters, I think there is. I'm sure Judge Murphy will make some comments about mandatory sentencing requirements in a moment, but in common law, personal injuries cases, for example, where someone has an injury, and let's say that injury is a badly broken left leg, the Court of Appeal sets down broad parameters about the range, and only the range, of compensation which might be available. So just to pick figures, $0 to $1,000. Somewhere within that range, the Court of Appeal will say to us, depending on the circumstances of that person, you, the trial judge, will allocate a sum of money. And as Judge Murphy has said, some judges will have a view that it's closer to the $0 end, and others will have a view that it's closer to the $1,000 end. But I do think broadly, there is a fairly wide discretion available in personal injuries cases in the common law division. Judge Murphy, in mandatory sentencing terms?
Yes, well, that's been something that's happened literally in the last decade or so. There's a lot more lack of discretion by judges in relation to particular criminal charges. Thus, and the charges themselves have changed in a sense. To take carjacking, which is an offence that people might not have heard about, say, a decade ago. It's now, it's the theft of a car using violence with a weapon. And so the court, the Parliament has said that if you steal someone's car and you use a weapon at the time to achieve that, then you're going to get 3 years jail minimum, full stop. No ifs, no buts. Similarly with a home invasion in company, An aggravated burglary, if you go into a house armed with more than 2 of you, that carries a mandatory minimum sentence again of, I think, 3 years. Or if you assault an ambulance officer when they're trying to put you in the ambulance, or then cause them an injury, you're going to get 6 months in jail. So all that's come in the last 2 or 3 years. So there's a lot more mandatory sentences have come in, and they take culpable driving, which is driving with a gross degree of negligence causing the death of another person. Then in the normal course, Parliament has said 8 years imprisonment, whereas probably 5 or 6 years ago, the judges would have imposed a sentence of about 4 or 5 years. So in response to community attitudes about sentences, Parliament has responded by imposing mandatory penalties, mandatory minimum penalties in a number of areas. There's often some sort of relief valve if someone commits an offence, but they're under psychiatric condition at the time, or gross hardship the penalty would cause, then the mandatory penalty might be able to not be applied. But in general, there's been a trend to these mandatory sentences in a number of criminal fields.
Thank you very much, Judge Murphy. Well, that just about concludes our session there today. I just really want to thank you, Judge Murphy, Judge Marks, and Judge Pillay, for your time. And thank you to all the students and teachers who attended this event and for all your great questions. If you haven't already, please visit our website and check out our free educational resources. If you can't make it to some of the other events we have on during the week, or you missed out of some of this event, we'll be making the video recordings available next week. So watch out for that email, along with a quick feedback survey we'll send out to you. And that's everything here. Thank you for coming on, and we hope to see you again in court.
Thank you.
Thank you, Ryan. Okay.